Hi, my name is Genevieve Shingle Jaffe, and welcome to the training on making legal a part of your biz. So before I jump into the content, I wanted to just give you a little bit of background of who am I. So Sparkly Lawyer is my title. I started my business in January of 2014, and before that, I was a Manhattan corporate lawyer. I was really miserable, so I left and started my own practice. In my business, I'm known as the Sparkly Lawyer, and a lot of people are like, what is that? And well, it's just me. I'm very bubbly, very pink, very sparkly, love glitter, so I try to infuse my personality when I teach law, which can be a very boring subject and scary, in fact. I am a former nationally competitive gymnast. I competed for Penn State. We are, if anyone here is a Penn Stater. And so that picture right there is me doing some flips off of the uneven parallel bars. My wife is Jordana Jaffe, another entrepreneur. She's a Facebook group expert. You may have heard of her. I am the co-creator of Damsel Goes Bear, which is an online legal course that I created with Lisa Fraley, another lawyer who's amazing. I am a Gemini, and I'm a true Gemini. I have like 12 personalities I like to joke around about. And I am a lover of unicorns. I love them. I think they're amazing. I totally liked them before they were super cool. And very proud of that. And this is all part of my brand, Sparkles, Unicorns, pink glitter, everything like that. And while it may not seem very lawyerly, it doesn't matter to me because it's who I am. So I really infused myself into my brand. So that's a little bit about me. Now on to the good stuff. So I hear this all the time. Why do I even need legal? And a lot of people, they don't want it. They don't want to deal with it. They think that it's something that they have to wait for until they're really making it big, that nothing will happen to them. But really, law is all about protecting your beautiful business booty. And it's not here to scare you. And at least the way that I teach it and offer it, I'm not about scare tactics. That's not how I sell. That's not how I market. It's really all about protection, and that's how I talk about it. So it's really there to protect all of the amazing things that you're creating and offering to the world. And the client contracts, which I will talk about, are there to protect your clients as well. So really, there's this mutual energy exchange between the two of you saying that I promise to deliver and I promise to pay. So it's all about protection, just making sure that what you're creating, what you're doing, your beautiful gifts that you have are being protected. And do not wait until you have clients. You should have contracts in place ahead of time because as soon as you put yourself out into the world as a business owner, you are opening yourself up to liability. So the second that you announce business, the second you are exposing yourself. Again, not about being scary, but I'm about informing you of what it's all about. Also, legal is not a DIY kind of subject. So I like to tell people that you wouldn't try to stitch up an open wound. You would actually go to a doctor. So let's leave the legal up to the lawyers. We know what needs to go in the contracts. We know what's important to include depending on your specific business. Contracts are crafted for a specific business, a specific offering. So that's a little of why you need it in the first place. So I want to start with the basics. What is a contract anyway? And we learned this in our first semester of law school. So a valid legal contract is an offer plus acceptance of that offer plus consideration. And consideration is defined as a bargained for exchange. And usually that's money. So, hey, I'm offering this coaching program for, $10,000. Great, I accept it. Here's the money. Awesome. And you obviously sign the contract, boom, you have a valid legal contract. So just a little background for you. Now, what do I really need? So there's so much out there, right? There's so many contracts, there's so many different things. So I want to just start with the 3 most important documents. And depending on where you are in your business, you might have other needs. But if you're just starting out or you're really growing, these are the most important things you need to have. Client contract is the number 1 most important document that you must have if you are a service-based business. As I said before, this document protects both you and the client by making sure that you both get what you bargained for. I'm going to go more into details of client contracts in a minute, but that is something that is a must-have. There's no excuses not to have it. The next are the website documents, terms and conditions, and privacy policy. These are two documents that are required to be on your website. So if you go to a website, if you go to mine, if you go to google.com, if you look in the footer, there will be a section, and people use different names. It could just be terms, it could be privacy, it could be legal, but there'll be a little link that you click on, and up will pop the actual terms and privacy policies for that specific company. So these documents basically, the terms protect the content and use of your site. So it claims that everything on your website belongs to you. The privacy policy protects the information that people provide to you when they visit your website. So maybe they're giving you a name and an email for a newsletter. Maybe you're collecting payments on your website. You are promising that you will not sell their information or spam them. That's what the privacy policy is all about. And the government's really kind of going hard on making sure that these documents are there because of all the internet piracy that's going on in the world. So what exactly is in a client contract? So there's lots of things that are in there, but here's some of the most important things. So if you're offering some sort of program, you want to describe the program. We want to give as much detail as possible because we want to make sure that when our client signs this document, it says what it is that I am promising to give as the coach or as the service provider. The cost, how much is it? How am I accepting the payment? So is it going to be, via PayPal? Is it going to be a check? What is it exactly? And is there any sort of penalty if you miss a payment? You can do that. However, it has to be quote unquote reasonable. Now the law doesn't define this for us, but it can't be something that is, astronomical, dependent upon how much the contract is for. Maybe it's just a $25 fee. Maybe it's $50. Maybe it's a 3%. You kind of have to figure out what you think is fair in terms of what it is, what the contract is for. The refund policy, very important section to provide because, as we know, many people are going to ask for a refund. We can't please everyone. People have different situations come up in their lives. The most typical refund policy is that there are no refunds at all. So I hear this a lot. Somebody decided to leave my program halfway through. They don't want to pay anymore, but in my contract it says you must pay in full even if you don't complete the program. I am very much about karma-based. And if I'm not delivering, if I'm not continuing to provide them with a service, do I really feel good about continuing to charge them? The answer is it depends on you. I like to tell people that you can charge a penalty for breaking the contract. You absolutely can continue to charge them because it is in the contract, but it's really about what feels good to you and how are you going to get the money from that person. If they're in a financial strait, then you might want to set up some sort of payment plan for them to continue to make the payments for you. Confidentiality section is all about protecting everything that you learn from the client as well as what the client learns from you. So all of the materials that you give is confidential. They can't share it with anybody else. There's another section that's included about intellectual property ownership so that all materials belong to the company. The client can't give it to somebody else or sell it to somebody else, that it belongs to you. So if they try to start a program that is exactly what you're doing with the exact same materials, you can go after them as they breach the contract. Very important section that is not in a lot of contracts I see is a disclaimer section. This is where you are actually saying what you are not providing. So let's just use an example. Maybe you're a health coach and you're not licensed in anything, and that's fine. But you would want to make sure that you say, I am not a medical professional. I am not a therapist, any sort of, psychiatrist, psychologist, nutritionist, dietitian. You want to make sure that they know ahead of time what to expect from you. And then you want to make sure that you say that, look, if you're having any sort of medical issues, that you do go see your specific medical doctor. So this is important, especially with business coaches as well, to say, look, I'm not a lawyer, I'm not an accountant, I'm not a financial advisor, planner, any of that, because our clients come to us expecting to get a lot of information, and especially, if we have had a lot of financial advice, tax advice, legal advice, maybe we'll say to them, this is what I've done, but that does not constitute that specific advice. So you want to make sure that they're not relying on you for that specific information. Whenever I have a client, with my clients, I tell them that they should also get an initial by that section to make sure that the client actually read that section. It's just a little marker point just to make sure that they saw that section. Not required, just a bonus. A dispute resolution section is there in case there are any issues. Okay, so my client breaks the contract. What happens now? I usually like to have something called an escalation clause, which means first we try to work it out by ourselves. If it can't work it out by ourselves, maybe then we will move to mediation. If that doesn't work, then we're going to move to arbitration. If a contract isn't really more, if you're not suing somebody for more than like $50,000, it really doesn't make sense to go to court, even probably 100 grand. Court is long, it's expensive, and most of the time you settle anyway. So most lawyers in our industry will put in an arbitration clause. Arbitration is a lot more cost efficient and time efficient. So, and again, it's going to settle most of the time anyway before you actually go to arbitration. So that's why I really, really, really encourage having some sort of amicable discussion between the two of you to try to settle it and come to a resolution without having to, hire lawyers on both sides, hire arbitrators, and get it all settled like that. The governing law section is what law is going to govern this contract. You as the contract drafter have the benefit of being able to choose this specific law, and it's going to be the one where your business is registered, where you're running your business, because that is the law that you have to comply with anyway when you are running your own business. Also, where the law is governing the contract is usually where you would host a dispute anyway. So let's say that there was an actual arbitration that we had to go to. You can say, hey, you've got to come to me. If you have international clients, sometimes you would be able to do some sort of electronic mediation or arbitration, but that's getting into a lot more detail. The last really important section that I don't always see is a no guarantees clause. So a lot of coaches have, maybe they're working with 10 different clients at one time, and one is like mega successful. They're breaking down barriers, they're making six-figure months, and other people are coming to you now because they say, hey, I saw that so-and-so has been making consistent, 5-6-figure months. I want to work with you too because that's where I want to go. This section is going to say, just because other clients of mine have achieved a certain level of success does not guarantee that you are going to achieve the same level. This is because we all have different work ethic, we have different goals, we implement things differently, we're in different industries. Some clients are just not going to put the work in as much as another. So we have to say, look, these testimonials that I have on my website, these people that are promoting me, it doesn't mean that you are going to achieve the exact same level of success. So you know that ahead of time, you're still going to work with me anyway. If you don't achieve that level of success, it is most likely not my fault. So client contracts in a nutshell. Now, there is a way that you can have online acceptance of a contract, and this is going to be called a terms of purchase or terms of use. People have different language for them, and this is basically when you house a contract online, which is very much like a client contract, but it doesn't require an actual signature. So if you're going to be selling group programs, online products, online digital programs, if you're selling your one-on-one work online, you're going to have documents on here that you don't actually have to have a signature for. This is great. I love it. It's perfectly legal, and it saves a lot of time and energy on both of your parts without getting the actual signature. So this is an example of an actual invoice that I use to the right here, and it says, by clicking submit, you are agreeing to the purchase agreement. You can click on that purchase agreement link and up will pop the document. So as it says here, the link to the terms must be easily available for viewing before the purchase is complete. So this is my invoice. They put their credit card information here. Before they hit submit, they have an opportunity to review the terms of my contract for whatever it is they're purchasing. If they don't click on that link and review it, it does not matter. Because they had the opportunity to review it, they have agreed to it by clicking submit. So there's two ways that you can do this. One is just saying by clicking submit, you're agreeing to the terms. The second way, and it is more of the golden standard, is to have a little checkbox. And they can't hit submit until that little checkbox is clicked. You'll see this all the time if you're on iTunes, if you're trying to purchase something, if you're upgrading your phone or anything like that. That is not required, but it is best practice to have that little checkbox there. And when they click submit, they are agreeing to the actual contract, again, even if they didn't see it. But it has to be easily available. So you can't have it in super teeny tiny font all the way at the bottom of the page, not near the submit or purchase button. It has to be right there for them to be able to see. And they have to actually be able to click so that they can review the terms of the contract. So law is all about notice. What did the client know before they made the purchase? I want to talk a little bit about intellectual property. And intellectual property is something, it would be either a trademark, a copyright, a patent. It's ownership, different ownership in a company. So a company would own a trademark, a copyright, patent, what belongs to the company. So a trademark, and the US Patent and Trademark Office defines a trademark as a word, phrase, symbol, or design, or it can be a combination that identifies and distinguishes the sources of the goods of one party from those of another. So basically, this is all about brand identity and preventing brand confusion. So we have examples of this would be Coca-Cola, the McDonald's Golden Arches. Something that's not as obvious would be Christian Louboutin, the red sole of the shoe. That's actually a trademark. And NBC's 3-note chime. So when you hear the do, 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 right, that wasn't very good, but when we hear that, we think, oh, NBC. So it's all about brand identity and brand distinction. So it can be your business name, it can be a program name, it can be your logo, anything like that. On the other hand, copyright is literary work, musicals, painting, sculptures, and other artistic works. These are what is typically a copyright, and it protects the form of expression as opposed to the subject matter of the expression. So there must be some element of creativity and originality in the work. So again, when we think of music, lyrics, books, some sort of painting, so it's how it is expressed. Whereas again, a trademark is just the straight up word, the logo, and logos can fall under copyright and trademark. I'm not getting into that because it's a little bit confusing, but that is just the overall distinction between the two. So I want to give you some top tips before we finish. So a client must see the contract before they pay you. As I said, law is all about notice. So if you're going to try to accept money over the phone, a lot of clients will do sales calls, accept money over the phone, send the contract via email before you process their credit card. While you're on the phone with them, send it. Have them review it and then write an email that says agree, or have them actually sign the document, whatever it is that you're using. A minor can never sign a contract. If someone is under the age of 18, a parent or legal guardian must sign on his or her behalf. If you try to get the minor to sign it, the minor has the opportunity to void it, and it will absolutely be void immediately because they are deemed to be unable to really understand what it is they're signing. I always advise that you send a PDF version of the contract to your client and you sign it last. So the easiest way is to use an e-signature platform, maybe HelloSign, Adobe EchoSign, something like that. This way, if it's a PDF version, they can't make any changes. Do not download a contract off the internet. You don't know what it's going to cover based on what it is that you are offering. It could be completely different. Maybe you see something that looks good, but it's a health coach contract and you're a business coach. Like I said, contracts are crafted for a specific business. This doesn't mean that purchasing templates are always a bad thing. I sell templates on my website, but they're crafted for people in our specific industry. And a little tip here is that you can protect your intellectual property now by putting the little TM symbol on your signature words or phrases. The little TM symbol just shows that you have an intent to file down the line and you're claiming this as your own. The little R with the circle, that means that it's an officially registered trademark. So you can't use that until you've officially registered. And any of your creative works right now, you can use the little C with the circle, the copyright symbol. As you can see below, I have the copyright symbol with Genevieve Shingle LLC, which is my LLC business name. So I am claiming ownership of these slides that I created. And if you have any questions at all, please feel free to reach out. My website is geneviveshingle.com, and you can contact me there. I'm all over social media, but I look forward to hearing from you. I hope this was helpful. Bye!